Hello. This week you're going to be reading Chapter 12, which is the judiciary, and I want to talk for a little bit about the role of the Supreme Court in our judicial system. First of all, the Supreme Court of the United States is not a typical court. It's not like a trial court where you might go for jury duty, or it's not like even a lower level federal or state appeals court. The role of the Supreme Court really is much bigger than the roles that other courts have. The role of the Supreme Court is to interpret the meaning of the Constitution. So it plays a very important role in our system of checks and balances. You read about checks and balances back in Chapter 2, so you learned that the president can veto bills passed by Congress, Congress can override presidential vetoes, and one of the most important roles in that system of checks and balances is the Supreme Court, which has the authority to strike down laws that have been passed by Congress. I should also mention that the Supreme Court can strike down state laws if those laws conflict with the U.S. Constitution. One thing you should know is that the Supreme Court does not go in before the fact to decide whether a law is going to be constitutional or not. It only goes in when someone brings a challenge to an existing law to the court. And that challenge has to work its way through the normal court system, so it has to go through the trial court, through at least one or two appeals courts before the Supreme Court would even consider looking at the case. And then they operate on a principle that says that they will only look at cases that they really believe deserve their attention. So most of the cases that are brought to the Supreme Court every year are not heard. They don't actually hear most of the cases that are brought to them. Their role is to decide the meaning of the Constitution. So they are going to look at cases where there is some question about what the Constitution means on a given issue or a given topic. So when they're looking at cases and when they're deciding the cases and so forth, they're asking the question, what does the Constitution say on this issue? Remember that the U.S. Constitution is the supreme law of our country. So the Supreme Court's job is to make sure that all the laws that are being challenged are in fact okay with the Constitution. So there are some concepts that are discussed in Chapter 12. One of those is the concept of judicial review. Judicial review is simply the idea that the Supreme Court has the authority to look at the constitutionality of laws. The first time they ever did that was in the very famous case of Marbury versus Madison, which is discussed in Chapter 12. And that's the first time the Supreme Court ever struck down a law and declared it to be unconstitutional. Two other principles I wanted to mention are judicial activism and judicial restraint. Judicial activism is a philosophy of the court that they should actively strike down laws when they believe they conflict with the Constitution, so that they're more willing, if a justice is following the philosophy of judicial activism, he or she is more willing to strike down laws, declaring them to be unconstitutional, in an effort to make sure that the Constitution is being followed. So they are not afraid to strike down laws, even if it's a controversial decision to do so. Keep in mind, of course, that the Supreme Court justices are not elected. They are appointed by the president, confirmed by the Senate, and they serve for life, so they don't have to worry about being reelected. Their job is really to guard the Constitution. So if they follow the philosophy of judicial activism, they're more willing to strike down laws and declaring them to be unconstitutional. But the other philosophy is judicial restraint. Some justices believe that they should defer to the wisdom and the actions of the elected branches, which would be the president and the Congress if you're talking about the federal government, or state governors and state legislatures if you're talking about the states. Again, keeping in mind that the Supreme Court can strike down state laws as well. So if a justice is following the philosophy of judicial restraint, he or she is less likely to want to strike down a law, even if they might see some problems with it. They are less likely to want to strike it down, believing that they should really defer to the wisdom and to the judgment of the elected branches of government. So again, judicial activism, justices are more willing to strike down laws, declaring them to be unconstitutional. Judicial restraint, justices are less likely to want to strike down laws. And each justice will have his or her own philosophy about how they approach those issues. And again, keep in mind that the concept of judicial review is that the Supreme Court does have the authority under the Constitution to strike down laws. They can strike down either federal laws or state laws if they believe those laws are in conflict with anything in the Constitution. The Constitution is the supreme law of our country. All right, so please make sure you read those pages carefully. If you have any questions about what any of these concepts mean or any other philosophies that are discussed in Chapter 12, please feel free to email me. All right, have a great week.